Welcome back to the fifth installment of Startup Law for Founders. As ever, I'm joined by Francesco for this conversation, and today we're going to cover intellectual property, which is really the lifeblood of a startup, of an emerging growth company. These assets that you're looking to commercialize and scale, and draw these resources around. Francesco, just to kind of kick things off, what are the various kinds of intellectual property that a startup would be dealing with?
So, intellectual property, falls in four major buckets: patents, copyrights, trademarks, and trade secrets or proprietary know-how. And those are the four things that in an emerging company you want to kind of keep an eye on, protect, and be aware of, and make sure you're using them, using your intellectual property, protecting your own intellectual property, but also being mindful not to step on anyone else's toes, so to speak.
So it sounds like you're saying what there is kind of a defensive posture. You want to protect what you are creating, but also an offensive posture. You don't want to, attack or infringe on somebody else's intellectual property either.
Yeah, that's right. I mean, there's really, there's when it comes to intellectual property, it's number one about protecting your own and also defending your own and making sure nobody else is infringing on your rights. But you also, want to be mindful of others' intellectual property, others' patents, others' trademarks, and make sure, for example, when you're launching a product or a brand, that you're not stepping into a lawsuit.
Yeah, that's not probably something most people want to experience early on in a company's life cycle.
Yeah, no, I mean, it's really it's a painful thing to happen in an early stage company, but it does happen, and it's kind of a tried and true tactic of kind of big incumbents as well, to bring lawsuits against upstarts, trademark related things, patent related things, or other stuff that that's kind of designed to snuff out these companies while they're young. So you have to be thoughtful and careful and prepared as you're entering into a market.
So as a founder, if I have an idea, I've maybe built something around it. Maybe it's the start of an MVP with some code. Maybe I have some designs, a word mark, a website. What are the next steps? How do I know what kind of intellectual property I have and the best ways to go about protecting it?
Yeah, so I mean, I think that you really need to be thinking about, for the most part, you really need to be thinking about, number one is the invention such that it might be patentable. And patentable inventions are ones that are, number one, kind of novel, non-obvious, and useful. Those are the kind of like trademark. That's funny. The baseline requirements under U.S. patent law and most other patent law systems. And I should caveat all this by saying I'm not a trademark lawyer. We're not trademark lawyers. We use experts. But there are some big picture kind of principles that that we need to be aware of to properly advise startup clients. So if you're dealing with an invention, an advancement that really that is potentially patentable, then there's some real key things that you need to be aware of. Like one of them is that there's in U.S. patent law, there's a public disclosure rule, so that if you publicly disclose your product or invention and you don't file a patent application within a year of that public disclosure, you lose your patent rights. And that's a pretty draconian rule, and it's even more draconian in other jurisdictions. So so if you're developing a product, and it's important to protect the confidentiality of it through NDAs, and um, and and other means like NDAs to ensure that you don't run afoul of this public disclosure rules during the development process. And that means that generally speaking, before a public launch of the product, you want to consult with a patent lawyer to see if patents are if the invention is patentable and whether patents make sense. Even if something is patentable, it may not be a strong enough or defensible patent. So there are other kind of considerations, that go into it. Including, cost benefit calculus, right? So like in the patent dimension, the key thing is really to understand this public disclosure rule. And then, if you're dealing with a product that you think might be patentable, making sure you're protecting its confidentiality and getting consultation during the incubation stage. The other thing to note about patents is that a patent protects your own invention, but it doesn't mean that launching that invention won't infringe upon somebody else's patents. And in other words, having your own patent doesn't guarantee that your product will not infringe somebody else's patent. And I find that very confusing and kind of
it is indeed.
But it is possible to have overlapping claims in patents such that in order to practice my own patent, I would actually need to incorporate or use somebody else's patent. So I would need to license somebody else's patent to fully practice my own. That is a very sort of counterintuitive and surprising, feature of patent law. And it again, like, it suggests the need to take this two-pronged approach of protecting your own, but also being mindful of what else is out there. So that's why patent lawyers have two opinions that they provide when you're launching a product. One is a patentability opinion, that is your invention, likely to obtain a patent? And two is the freedom to operate opinion, which is a totally separate thing, which is, will practicing your patent breach anybody else's, violate or infringe somebody else's patents? And so if you're launching in a large market with some well-heeled incumbents, I think it's really important to be mindful that you may be stepping into a patent infringement claim, and that there are avenues for doing your due diligence around that.
Yeah, so this is very counterintuitive to have these overlapping kind of pieces to this, and really I think underscores the complexity of this for a company, and the need to really make sure that you're doing it right, that you are consulting with the right experts to give you these opinions and see these things through.
Yeah, it is. I mean, it's a really complex, I think, calculus, and it's costly as well. I mean, it's and then having the patent is one thing. Then there's defending it and asserting it against others, and that can be costly as well. So it's a complex set of business considerations that goes behind patents, but it is an important part of the business landscape. It's an important part of many companies, the defensibility of their products and their competitive moat. So in many industries, it's key to be on top of it, for sure.
So this is a pretty big, complex, and interesting bucket of intellectual property. The next one, trademark. This is one that maybe people have a little bit more familiarity with. You see the little TMs or the R's next to logos and word marks. Just last week, it was reported that LeBron James is seeking a patent for Taco Tuesday, this viral Instagram thing that he's been doing over the off season. And those kinds of stories will pop up from time to time in the news. But what are the things that a founder should be considering in this bucket of intellectual property?
Yeah, so trademarks protect, brands. They protect they protect brand elements as well. So not just the name of your company, the name of your product, but things like logos, like the Nike swoosh, or like taglines, and even potentially the look and feel of a particular brand, like the look and feel. What's called trade dress is like the look and feel of a restaurant. Its decorative scheme can be so distinctive that it's a signifier of a certain brand of restaurant, right? So the key purpose of trademark law is to help consumers know that they're getting, when they're buying a product from a certain brand, that they know what they're getting. So if I have a brand, if I go to buy a pair of Nike shoes and it has the Nike mark on it, I know who made it, I know what company it came from, and um, and that is valuable to a well-functioning marketplace. Now, if a company comes along and uses something confusingly similar to the Nike swoosh or the Nike brand name, consumers might come in and buy that product thinking they're getting a Nike, and in fact getting something else. So they're kind of like, in a sense, misappropriating, taking advantage of, and hijacking somebody else's brand equity, right? So that's the quintessential case of trademark infringement. So for really, for companies that are, um, launching into something broader than just a real local market, like if you're launching into a regional or statewide, or certainly a national market, trademark protection is really important. It is important for, again, this twofold reason. Is one, you want to be able to build equity around your own brand over time, and you want it to be protectable over time. And so getting trademark protection at the onset gives you that assurance that you're building on something, that you own, that has certain protected rights, and that you can protect against others' infringements. The other thing is that, in a trademark, like when we do a trademark application, there's also the process of, well, what else is out there, and who is using brands that are similar to this, and how similar are the brands, and is there going to be any confusion? And that tells us, number one, how strong of a trademark you have, how likely you are to get the trademark application approved, but also, if you launch this brand, are you going to be infringing on somebody else's trademark, which is also a really important consideration.
So here again, you get the kind of offensive, defensive postures, both operating in concert. And, this is an area where, I've heard and seen on the internet a lot of kind of unofficial advice to, this is easy, you can do this yourself, you don't need a lawyer. But really, this is such a foundational piece of a new venture in a company that can matter for a long time down the line in both this offensive and defensive aspect.
Yeah, no, I mean, there are a lot of course, do-it-yourself services, and I'm not really one to poo-poo any of that. They serve a function. But that being said, when we do trademark applications with our trademark counsel, we can there's a lot that goes into the strategy behind seeking trademark protection. What the scope of protection that you're obtaining in your application, how to kind of thread the existing marketplace, to carve out as big a space as possible with your brand in terms of trademark protection. but then also doing this, the trademark search and evaluation of the strength of the brand and its and the likelihood of infringing on other brands. It's a valuable piece of the application. So, as founders, you're investing a lot in a brand and building a brand and the collateral around it and so forth. It's really a relatively cost-effective investment to make sure it's, to make sure that the trademark law is behind you and will protect the investment.
So that's two buckets. Going down to our third bucket, copyright. Again, something that I think most people have a little, kind of a surface level understanding, whether that's related to music or, the FBI warning that you would see before a VHS tape at home. But what kinds of things are copyrightable? What should a founder be thinking about related to copyright law as they're launching a company?
Yeah, there's, so copyright law protects creative expression that's that's been fixed. It's fixed in a fixed medium of expression. So a creative YouTube video, it has to be original content, but that bar is pretty low. So like a YouTube video, a photograph, a novel, a screenplay, a film, all of those are fixed, tangible, creative works, and they're all protected by copyright law, and they're protected automatically. In other words, like my creative work product is automatically copyrighted, but registering it with the federal government gets me certain additional rights and protections for my copyright. A lot of businesses, there aren't all that many. The kinds of businesses where copyright law becomes extremely relevant are content oriented, for obvious reasons. Their business is copyrighted content, and whether it's their own original content or it's they're a platform for user generated content, the copyright protections and copyright laws are extremely important to the mechanics and economics and functioning of those kinds of businesses. For other businesses, copyright laws come up less frequently. So we don't see and we don't deal with copyrights as much in the day to day of our work as much for those reasons. Other than we do represent a couple of platforms that do host user generated content, and so in those cases, the terms of service and user license agreements, things like that, you need to understand how the copyright laws are working there.
Yeah. Well, and in the kind of state of the world that we are living in now, I heard one executive of a hotel company say every company is now a content company, given the ubiquity of social media and these really content-heavy, content-driven marketing and sales efforts, which means that it may not come up as much if you are a YouTuber or really engaging in this content creation as a core functionality of your business, but still something that people should be mindful of.
Yeah, I think it's useful to understand what copyright law protects and to be mindful of it. I don't know if I agree with that assessment. Like, there is a ton of content out there, but how much of it is really valuable and worth protecting and so forth, I'm not so sure about that. But it is, again, in certain businesses, it's absolutely critical. So we do. So it is important to kind of like keep an eye
on it. Sure. So copyright, that's bucket number 3. On to number 4, which is trade secrets, proprietary information, which might be a little more amorphous, maybe unclear to some folks.
Yeah.
What are we dealing with here? What is this universe?
Yeah, it's kind of different from the previous three buckets, because the previous three, you can actually file an application and get a patent from the U.S. government. You can get a trademark from the U.S. government. You can get an official notice of your copyright registration from the U.S. government. But trade secrets aren't really like that. Trade secrets are the kind of know-how and ways of doing things and techniques and processes that you've developed in your business that enable you to run a successful company and kind of beat your competitors, So a quintessential example of that is a recipe, like the recipe for Coca-Cola is probably one of the most valuable trade secrets there is.
Sure.
It's not patentable, but it's extremely valuable. And as a trade secret, as a trade secret. So that's what trade secrets are. Things like customer lists, their proprietary processes, and proprietary methods, and proprietary data, and things of that nature. Stuff that is internal to your company, that really kind of it has commercial value. And even though it may not be subject to protection from those other IP buckets, still obviously very valuable, and it's protected by law. It's protected by law in that it is unlawful to misappropriate trade secrets. In the news right now is a quintessential misappropriation of trade secrets, a criminal case brought by Waymo against somebody that went to Uber with downloaded a bunch of proprietary technology, computer files and things like that, and took it over to Uber, and there's a big civil case, and now the federal government is actually prosecuting him. So trade secrets are most definitely protected under civil law as well as criminal laws. Now, the way that you win the protection, the way that you assure yourself as a founder and as a company that you assure that you get the benefit of those laws, is by treating things as trade secrets. And that means that you got to label things and identify things as trade secrets, and make sure that people who come in contact with your trade secrets are signing confidentiality agreements, CIIAs, and the degree of trade secret protection, very much revolves around the degree to which a company regards its trade secrets as such and protects them as such. So if you're kind of freely sharing stuff without indicating its value and so forth, it will suggest to a court, that these aren't actual trade secrets and they're not entitled to protection because the people that came in contact with it had no basis or reason to know or understand it. So it's important to have processes, contractual processes in place, but also other kinds of processes relating to access to data and files and so forth, that reflect the value you're placing on your proprietary know-how.
Yeah, interesting kind of setup and posture for this grouping. As you said, with these first three, you're interacting with a government entity who's going to approve, hopefully, your application, your trademark, etc. Here, it's really incumbent on the company itself to monitor and protect, especially vis-a-vis the people that they are bringing in as employees, as consultants, advisors, etc., to make sure that they are also protecting that information.
Yeah, that they're aware of its confidential and proprietary nature, and aware of the restrictions around its disclosure, and that they agree to to provisions protecting that confidentiality.
And that really underscores that those documents as part of an onboarding package that you are engaging with that new person.
Yeah, absolutely. Going back to the service provider lesson, whenever that is a big part of the onboarding process, is ensuring that a company's IP is looked after in this way.
Interesting. A lot of moving parts in the IP arena to keep in mind as you are building out these ideas, making them come into the world.
It is. It's a toolbox. It's a powerful toolbox for founders, and it's good for them to be aware of these tools for building like a competitive moat about their company, and then just kind of being aware that there are others out there that are also using the tools in the market, and so it's good to know. It's good to know kind of how they work.
Yeah, for those folks listening and watching on YouTube via our newsletter, there's a lot more content you can check out. Talking with other experts who are dealing with a lot of these issues, such as hiring, IP protection, and reach out. We're here if you need us.
Thank you, Chris.
Thanks, Francesco.